Hi everyone, this is Daniel Chesmore, continuing on with our constitutional law lecture and review for the bar exam. We last talked about separation of powers, federal executive power, limits on state regulatory and taxing power. We talked about removal. We talked about the Bill of Rights and the 14th Amendment regarding the due process clause, applicable levels of scrutiny, as well as the undue burden test, which is sort of its own level of scrutiny outside of rational basis review and strict scrutiny. We talked about a very general review over standing and judicial review, separation of powers, Commerce Clause, preemption, dormant Commerce Clause, and now we're ready to move on towards the First Amendment free speech rights, as well as the First Amendment religion rights relating to the Free Exercise Clause and the Establishment Clause, as well as to different public forums related to that First Amendment right of free speech. And if you need to go back to any of those prior concepts, please go back and review the prior videos. We'll try our best to keep this last video under an hour. So here, in regards to our analysis over free speech, we want to start with analyzing the government action. So similar to analyzing whether or not the constitutional rights apply in the context of a due process challenge or to any sort of related challenge regarding state action, the same logic applies to the First Amendment Equal Protection Clause. So very similar to how we were assessing government actions prior and determining the applicable level of scrutiny, when looking at a government action involving any sort of burden on free speech, we want to assess whether or not that law is facially neutral first. And what do we mean by that? We mean that we don't want to see any sort of animus towards a protected group with historical discrimination. We look at, for example, historical background, legislative history, and administrative history when making such a determination. But first off, we want to determine whether or not a government action is facially neutral, and by that not specifically targeting a certain class of people, such as targeting women or targeting those who are non-US citizens, or targeting members of a certain race or other protected class. So here we start with our analysis. We want to determine whether or not it's a facially neutral law. But even so, facially neutral laws may actually have a different level of scrutiny, either rational basis review, as we last talked about, meaning that the classification is rationally related to a legitimate government interest, or if it might be strict scrutiny, which applies to an equal protection challenge when the face of the law creates a racial class or a class based on national racial origin. So strict scrutiny, as we last talked about in our last video, is the highest level of scrutiny in which we look for not just a legitimate purpose regarding the rational basis review, but a compelling purpose. And it's beyond the rationally related requirement for the means test. It really has to be necessary or narrowly tailored such that the government means of achieving that compelling interest is really the only necessary way, or it's narrowly tailored such that we really need that government action in order to achieve that compelling purpose. So here, within facially neutral laws, we want to assess whether or not it's there's a discriminatory purpose and a discriminatory impact or effect. If those two conditions are met within the government actions, then generally strict scrutiny will apply. However, if we don't have both of these, discriminatory purpose or discriminatory impact or effects, then likely rational basis review will apply. So in each of these three scenarios here, when we don't have one or the other or neither in the facially neutral law regarding discriminatory purpose or discriminatory effect, we get rational basis review, as we talked about. So when making this determination, we really need to look at the totality of circumstances. Very similar words that we'll use in our criminal procedure lecture, really looking at the totality of circumstances in order to draw inferences of purposeful discrimination, where statistics alone are not enough. That just because there's a higher prevalence of, let's say, in that case of police officers of certain backgrounds who were precluded from actually being eligible based on some sort of standardized test, just because there are statistics that prove that members of a certain class of people are generally not able to pass that test, that alone, those statistics alone, are not enough to prove discriminatory purpose. We need something more. So in that McCluskey case, the government looked to statistics broadly without proving discriminatory purpose in absence of a civil rights statute allowing violation of the Equal Protection Clause on discriminatory impact without discriminatory purpose evidence. So again, you need both for strict scrutiny to apply, not necessarily RBR. And in the purpose of someone challenging a government action, it is in the challenger's benefit to get strict scrutiny for that law to be more likely to be struck down. However, there are cases in which the Supreme Court has found that strict scrutiny has applied, but strict scrutiny was actually met by the government, like in the unfortunate Korematsu case in which Japanese Americans were interned. Famous constitutional law case, very troubling piece of our history, but we have to remember that there are other examples as well in which strict scrutiny was upheld. And so that is still on the books, and as are other cases. However, we anticipate that eventually there will be some sort of clarity given from the court on that. And so statistics alone are not enough, and we talked about that McCluskey case where we really need both that discriminatory impact and discriminatory purpose evidence. Discriminatory purpose, we look for government action was taken because of its adverse effects upon an identifiable group and not in spite of an adverse effect. We need more than volition or intent as awareness of consequences. And the plaintiff must actually show the government's desire for outcome and provide for it. So another general rule here, race is a sole factor in school assignments where unless to remedy past segregation or use in range of factors violates Equal Protection Clause. That was the Parents Involvement Community Schools case. So if race is a sole factor in school assignments, unless to remedy past segregation or use in a range of factors, it could violate the Equal Protection Clause. We want to distinguish using race as a sole factor versus maybe as plus points in the context of education. We've seen that where to create diversity, there might be plus points, but we can't make public college admissions solely based on race. It can be one of many factors taken into consideration. However, we want to create equity across the board when we think about the Equal Protection Clause. However, to remedy past segregation, it is an interest worth noting. But however, we need a range of factors. Otherwise, that alone, using race as a sole factor, is likely to violate the Equal Protection Clause. So part of this analysis, we want to look for substantial departures from normal procedures to infer the discriminatory purpose. And so we talked about strict scrutiny, where it applies to equal protection challenge when face of law creates a racial class or a class based on national racial origin. And the court will most likely not recognize any group as quasi or suspect class. It depends based on a number of factors, the 3 factors here, when looking to whether or not we want to have a quasi-suspect class or suspect class. We look to the history of discrimination onto that class, mutable characteristics, and lack of political power. And we want to look at, in the context of strict scrutiny, if the classification is necessary to achieve a compelling government interest, and that that compelling purpose cannot be achieved through any less restrictive alternative as part of our necessary means test. And that's why necessary is underlined there. So remember that remedying effects of past discrimination is actually compelling, like here in that parents' involvement case, but you must first establish past discrimination. And we talked about this, but also diversity in education is compelling, and so is remedying past discrimination. There were some education cases, famous ones, that we studied in constitutional law. Maybe you might have studied this in high school AP US history or your US history class, where in Bacon Fullalove, they had the justices actually apply an intermediate scrutiny there, where in those cases, that's where we get our general rules on no quotas, that it was unlawful and a violation of the Equal Protection Clause to actually set aside racial quotas. But you also have that, you have some conflicts there where you might set aside a percentage of the class. However, generally, looking at that Richmond case where 30% of racial classification on face of plan is subject to strict scrutiny, even if purpose is to benefit minorities. We looked at inclusion of certain minorities as arbitrary, and racial balancing was not narrowly tailored to any goal. And there was no, and we don't want to create any sort of creditor or debtor race as part of our underlying logic for equal protection clause. We'll say EPC from now on, keep it short, for an EPC analysis. Breyer dissented in the parents' involvement case. He did say that differences between racial classes in defiance of, were actually found to be in defiance of the Equal Protection Clause, EPC, and race-conscious criteria to further purpose of the 14th Amendment. So within that, look at narrow tailoring. That part of that necessary means test is the narrow tailoring requirement. And to be narrowly tailored, we want no predetermined quota, but we can use plus points, as we discussed, when admitting an eligible applicant for the purposes of public college admissions. And so in that Grutter case, we get the general rule that racial classifications must be narrowly tailored to achieve a compelling government interest. So racial classifications, as long as they pass that narrow tailored and the compelling government interest test for strict scrutiny, they could actually be upheld. So that's an example where in that case strict scrutiny applied, but satisfied in Grutter since it was narrowly tailored to achieve its goal, where versus distinguished between an independent assessment for independent review, unlike parents involved. Remember that the goal of diversity is broadly defined as to achieve a critical mass of underrepresented students to break down stereotypes. However, Gratz failed strict scrutiny since there was no independent review. It was just an automatic 20 points awarded to members of a race. That's too much. Administrative challenges were not justified. And in Fisher, race was a factor of a factor. So that's distinguished from Gratz, where narrow tailoring was actually met in the Fisher case because race was not a plus factor for 25% of class. You don't need a racial neutral alternative. You don't need every single racially neutral alternative. We use documentation and admissions process records for a finding of the narrow tailoring requirement. And also remember that, as we talked about, remedying past discrimination may be a compelling interest. However, there are other criteria for this to be a compelling interest to pass the applicable level of scrutiny. It's got to be narrowly defined, such as a court order to desegregate schools. You need evidence of prima facie discrimination, and you need proof of intentional discrimination there. So private biases, however, are not applicable here, are not applicable since we're really applying the EPC to state actors per Palmore. So remember that compelling government interests are not, private biases are not included within the compelling government interests arguments. And so within different classes, that was very generally the introduction to EPC in the context of racial classifications. Again, if there is some sort of compelling purpose, narrowly tailored, evidence of prima facie discrimination, proven intentional discrimination, then it may actually pass. But look for maybe perhaps an absence of quotas, distinguishing that case in Gratz, the automatic 20%, because we don't want creditor or debtor races. We want real equality. And so alienage classifications, remember that the 14th Amendment states that no state shall deny to any person within its jurisdiction the equal protection of the laws. And that's where we get the Equal Protection Clause also, how it overlaps with the 14th Amendment and how it applies to state actors there. So there are two ways to trigger heightened scrutiny. Remember, we talked about it as facially discriminatory or facially neutral. However, facially discriminatory usually will be struck down. However, facially neutral can actually have, you can actually ratchet up the applicable level of scrutiny if you have both the discriminatory purpose and the discriminatory impact or effects. You can use either word on an essay, or they might be used interchangeably. So just remember, I put the slash mark between DI and DE for discriminatory impact, discriminatory effect, as we talked about before. So here, within the exception, there's an exception here for alienage classifications. We look to government functions, specifically like the Foley case, where no alien police officers were allowed, and they decided to not raise the level of scrutiny. They applied RBR, Rational Basis Review, as we'll use it as RBR as our acronym for sake of time. No alien teachers, because teachers were integral to civic values. And RBR for democratic process, such as to ban certain immigrant classes, non-citizens, non-legal residents from sitting on juries or voting or holding public office. And we want to distinguish this other case, Pyler, which a state denying undocumented aliens benefit of public education must do so to further a substantial state interest. So when they use words like substantial, it's like they're using a level of scrutiny kind of in between strict scrutiny and rational basis review, but we just remember that word substantial means a substantial interest. And so here, undocumented aliens were not considered a suspect class, because remember our factors for suspect or quasi-suspect: history, discrimination, immutable characteristics, and lack of political power. We think about that in the context of maybe disabled people, maybe people of a certain other protected class. However, that was not extended to undocumented aliens. And so remember, also poverty is not a classification to trigger strict scrutiny, since you might argue that poverty is not an immutable characteristic. And when we think about immutable characteristics, we think about something that you were born with, something that you can't change. So you can argue these three factors to determine a suspect or quasi-suspect class for a wide variety of social classes. In my constitutional law exam, we had one exam essay that related to transgender people, and we argued that transgender people were actually a quasi-suspect class because of scientific evidence that proves that the predisposition for gender identity is considered an immutable characteristic which someone is born with based on the scientific evidence. You can argue both ways on an essay depending on what the courts find, and so really take this analytical framework. Your conclusion really doesn't matter as much as your analysis. All the points are always in analysis, so the conclusion can go either way as long as your analysis is all there. So there is that is alien classifications in a nutshell. We look at the Craig case for gender discrimination, gender classifications. There are two ways to trigger heightened scrutiny. However, the court decided to create its own level of scrutiny here for intermediate scrutiny, somewhere in between RBR and SS for strict scrutiny. And remember that gender classifications, they must serve a important government interest. So distinguish between a rationally related or rationally reasonable or compelling, kind of in between when we use the word important. So remember that for gender classifications, we use intermediate. And I like remembering that intermediate starts with intermediate and important interest. They both start with I, so that's how I usually remember it for exams. And so it must serve an important government interest or objective that must be substantially related. It's distinguished between rationally related and necessary or narrowly tailored. It's important and substantially related to achievement of those objectives. And so in the Virginia case, states need exceedingly persuasive justification for gender classifications that categorically exclude women from educational opportunities. And so we distinguish gender-based classifications versus gender-related classifications. We said that Pregnancy Discrimination Act had to end discrimination against pregnant women, where that case held that discrimination on basis of pregnancy is not in itself a violation of the Equal Protection Clause. And remember that a remedial purpose will justify gender classification if it directly serves that purpose. Court rejects gender classification, which was premised on stereotypes. Stereotypes are viewed as suspect or suspicious. And in that case, Califiano, it reaffirmed and upheld the validity of Congress to remedy economic disparity between men and women resulting from discrimination in the labor market. So a remedial purpose seems to directly serve that purpose. However, Congress has that ability to remedy economic disparity as part of their constitutional authority, as we talked about. And so also arguments for strict scrutiny on gender discrimination, history of discrimination, immutable characteristics, significant underrepresentation in the political process, since most lawmakers are still men even in 2021. Sex has no relation to a person's ability to perform or contribute. Those are arguments for any sort of heightened scrutiny when it comes to gender classifications. But we distinguish gender-based classifications versus gender-related classifications. But also at the same time, we have arguments against strict scrutiny, where the EPC was intended to outlaw racial discrimination, since the EPC, the 14th Amendment, was passed in the context of granting equality and ending slavery following the Civil War. Some argue that strict scrutiny shouldn't apply because of biological differences likely to justify gender classifications. And women are the political majority in today's world, where women actually constitute most voters, I believe, when that was written, based on just the numerical statistics of voting records. So remember that we kind of apply this intermediate scrutiny. We look for an important government interest and something that's substantially related to achievement of that objective. We look at maybe perhaps there are justifications based on having differences in treating women versus men, and we saw that Pregnancy Discrimination Act had to end discrimination against pregnant women in that case, which held that discrimination based on pregnancy is not itself a violation of equal protection. However, I think a lot of this jurisprudence is still growing, and we'll see much of this change perhaps in future cases, and it's still a growing area. And so that is gender classification, and we talked about quasi-suspect, suspect classes, history of immutable characteristics, history of discrimination, lack of political power, and you can argue that in the context of raising strict scrutiny and raising the applicable level of scrutiny, and your results might change whether the courts apply intermediate scrutiny or strict scrutiny, depending on if the courts might actually say that this is distinguished between gender-based classification and gender-related. It might be based on stereotypes, for example, where stereotypes are usually viewed as a suspect and suspicious, and your conclusion might change based on the applicable level of scrutiny. And so it's perfectly fine on a conclusion to say that depending on the applicable level of scrutiny, we'll call it LOS for now, but depending on the LOS, the result may change based on the court. And so we move on from I think I misstated previously in I think a prior video. Remember that actually Equal Protection Clause, it comes from the text of the 14th Amendment. And so it comes from that no state shall deny to any person within its jurisdiction the equal protection of the laws. And so equal protection relates to due process, but it's a little bit distinguished. Our analytical framework is similar, but make sure not to mistake the two. That we're looking for different criteria here in our analysis. So now we can move on to the First Amendment when it comes to free speech. We'll talk about free speech first before we talk about the First Amendment religion clauses. So there are different categories of speech. We start with fighting words. Fighting words are generally speech directed at another, likely to provoke a violent response. They can inflict injury, usually by the mere utterance of those words, or when, and also we look to when can the government actually punish a speaker based on the violent response of others, of the audience, breach of peace, for example, and we look for expressions of hate. So again, speech directed at another, likely to provoke a violent response. When can the government punish a speaker based on those violent responses and expressions of hate? And we look to the provocation of an audience. And we look at content-based and distinguishing content-neutral laws, where content-based restrictions or regulations are generally invalid under the First Amendment. Content-based government regulations, even on low-value speech like fighting words, are unconstitutional. We don't want to censor folks. We want to look at the impact of protecting the peace versus actually censoring certain types of words. The government may regulate against action, against certain conduct, even if it incidentally burdens speech. So conduct is distinguished between speech. We saw that in many of the nude dancing cases. So remember that certain conduct may be regulated, even if it does incidentally burden speech. I think the arguments were made for nude dancing that it's a form of speech, but it's more related to conduct. Government may restrict speech where it is of such slight social value as a step to truth that any benefit is outweighed by the social interests in order and morality. So there, the modern test now is to look at the Brandenburg test, which is the government can step in to prevent fighting words when there's an imminent harm, where it is objectively likely to produce illegal action, such as that violence from the crowd or audience, and the speaker's intent to cause imminent illegality. So remember, it's more of an imminent harm test. We look at if we apply an objective standard, whether it's objectively likely to produce a harm or some sort of illegal action, and whether the speaker's intent to cause an imminent illegality. So licensing or permit laws require an important government interest. When we talk about, such as when a mayor is deciding placement of news racks, that is unconstitutional. Licensing or permit laws, you need to have an important government interest, such as protecting the peace or maybe protecting traffic, versus having protests on open roads. It might be more practical to have that important government interest of preventing traffic congestion. So that's why we might have a permitting license process for cities. We look to clear criteria, leaving no discretion to the government. Otherwise, it may be void for vagueness in analyzing a government action, and also procedural safeguards. Keywords here were prompt judicial review of denials. So you have some sort of appeals process if you're denied a permit. And you want clear criteria so that the government should not discriminate, such as in that interest of preventing traffic congestion and obstructing traffic. And an important government interest, so it sounds kind of like strict scrutiny there. Remember that when regulating unprotected speech, lawmakers can't single out speech based on the context within categories unless there's a content-based distinction which advances and a reason not protected, or there's a substantial class associated with particular secondary effects of the speech. The general rule that we have here is that the government cannot compel anonymous speakers to reveal their identities. There is no content-based restriction for unconstitutional law violating free speech requiring permit for door-to-door advocacy not narrowly tailored to money solicitations. So that's overbroad. So we look at the breadth of the law, if it's underbroad or if it's overbroad, overbreadth, underbreadth is part of our analysis. We look to, related to this topic before we move on, just remember that there's another topic of incitement of illegal activity, which sort of relates to fighting words and that Brandenburg test for fighting words. But this is the clear and present danger test, which was the old law, may possibly be brought back. The old law was that it was a reasonableness approach where state bans of unlawful overthrow of government are valid exercise of police power unless unreasonable. It was more of a reasonableness test. And so that was a clear and present danger test versus a reasonableness test. You can argue both since it really depends if we're going to go back in time, like the trend of the court to bring back old rules. Also remember that the First Amendment does state that Congress shall make no law respecting an establishment of religion or prohibiting free exercise thereof, abridge the freedom of speech, press, or right of people to peacefully to assemble and to petition the government for a redress of grievances. And that's where we get our free speech methodology, very generally, where in our analysis, we talked about fighting words, but in a general analysis of free speech, you need to first examine the nature of the restriction. Is it content neutral or is it content based? Remember that discrimination based on the message or the subject matter or the based on the content or the subject matter, that is actually going to trigger SS. And generally from Reed, we know that all content-based restrictions will get strict scrutiny. So we want to distinguish viewpoints, that usually if you're going to prevent speech based on viewpoint, that's going to get strict scrutiny. So content neutral usually will get intermediate scrutiny. Remember that it must be, the subject matter cannot preempt the topic, it has to be neutral, viewpoint neutral, or it's going to get strict scrutiny. And it has to be message neutral. So this is all part of the umbrella of subject matter neutral. We don't want to target certain speech or certain words. We want to really look at the nature of the restriction. And so you might have strict scrutiny apply or intermediate scrutiny based on that determination if it's found to be content neutral or content based. Argue both. Viewpoint neutral may also violate the EPC if prohibition of public discussion of an entire topic. So that's basically closing the venue or closing the forum for free speech entirely. And remember that, however, this is distinguished between time, place, and manner restrictions. Secondary effects also of viewpoint neutral restrictions, or I'm sorry, of viewpoint neutral, that will usually get intermediate scrutiny. And the government can actually win, though, if it can successfully argue that secondary effects, such as are actually unrelated to desire to suppress speech, such as that example of blocking traffic. Or perhaps maybe it could be noise disturbances during the SAT test. So within schools, we don't want to see protests when kids are taking the SAT so they can study. It may be viewed as passing that intermediate scrutiny challenge where there is an important government interest substantially related. And remember that the desire to suppress speech must be unique to speech suppressed as compared to speech allowed. Also remember that time, place, manner restrictions are generally okay if they're designed to serve a substantial or important government interest, and do not limit alternative avenues of communication unreasonably. That's part of the substantially related means and important for intermediate scrutiny. You can use substantial government interest, substantially related, or you can use important. You can use both words, just be careful. It depends on your preference. I think both are fine. If government regulation relates to expressions content, then it must pass intermediate scrutiny. If government's purpose is unrelated to suppressing expression, it must meet the less stringent standards. Government may make choices about spending, subsidizing, or may not actually discriminate based on viewpoint. The free speech clause does not apply to government speech. It applies to our private speech that the government tries to regulate through time, place, manner restrictions as an example. The government cannot function without right to engage in content-based speech. And that's from Walker, so we want to distinguish this. Remember, that may be a multiple choice question. Free speech clause does not apply to government speech. It really applies to the speech of regular Americans, and so, or just regular people, civilians. Underbreath, overbreath. Remember that overbreath, unconstitutional if it substantially sweeps in more speech than the First Amendment permits. So there was that Jews for Jesus case in which all speech was not protected by the First Amendment. It was too vague. That got strict scrutiny, so look for overbreath as part of your analysis. Look for vagueness. That relates to criminal law, where we saw void for vagueness, where it relates to procedural due process, which allows too much discretion for the government, and a reasonable person can't discern whether or not it's constitutional or not. And so think about void for vagueness doctrine, think about fairness, notice, and think about selectiveness when we think about procedural due process. Look for prior restraints. Now, prior restraints, look for a court order or licensing requirement or some sort of permitting scheme. And remember the collateral bar rule, which you're subject to even if you think the order is unconstitutional for court orders. So look for heavy presumption against constitutional validity. So even though your speech is unlawfully being suppressed by the government, let's say the government or a local municipality decides to ban content-based speech, you still have to follow any sort of ruling from the court, and you have to go through the judicial avenues to challenge it. That's part of the collateral bar review, or bar rule. So remember that if you think it's unconstitutional, you still have to follow that permitting scheme or licensing scheme or a court order. And you want to just look for a heavy presumption against constitutional validity. A heavy, quote unquote, prior restraint is basically censorship, effective censorship, and it's allowed, however, in narrow circumstances such as national security, obscenity restrictions, or protecting the peace. Remember that the collateral bar rule, sometimes you have licensing where the scheme is facially invalid, where you don't have to follow, if broad discretion based on vague criteria. We want to look for facial invalidity. So in certain circumstances, though, where you might have a licensing requirement that is unlawful, but it's facially valid, you still have to follow it. But if it's facially invalid, where you don't have to follow it, if broad, you don't have to follow it at all. If there's broad discretion based on vague criteria. So that's part of the void for vagueness doctrine. Also think about that Stewart case where court orders barring pretrial publicity by the media bear a heavy presumption of invalidity, which must be analyzed by considering 1, the extent or prejudicial nature of pretrial publicity, 2, if the order would mitigate publicity's effects, 3, how effective such an order would be, and 4, the order's precise terms. And remember here that an ordinance prohibiting some sort of a distribution of literature without permit is invalid on its face under the First Amendment. The collateral bar rule doesn't apply. Think overbreadth. We want to think about facially invalid if there's too much vague, if there's broad and vague, just broad discretion based on vague criteria, then it may be facially invalid and the collateral bar rule may not necessarily apply. So remember our general rule here that government cannot compel anonymous speakers to reveal their identities. And also remember that the collateral bar rule for unconstitutional law violating free speech requiring permit for door-to-door advocacy, it was not narrowly tailored for monetary solicitation. And so here we'll talk more about other types of speech. We'll talk about the general rule again. When regulating unprotected speech, lawmakers can't single out speech based on content within categories unless the content-based distinction advances reasons not protected or substantial class is associated with particular secondary effects of the speech. Racist speech, government may punish racist speech as group libel, not constitutionally protected if punishment is rationally related to preserving the peace. So think about distinguishing free speech versus group libel, where that group libel is not constitutionally protected if it is rationally related, if the punishment is rationally related to preserving the peace. Obscenity, states may restrict obscenity in the community, even that viewed by consenting adults, to further legitimate interests in maintaining order and morality. When they use the word legitimate, it sounds as if they're using rational basis review and based on conduct, for example. There's a Miller test that we can apply. And that Miller test is we first take the average person who applies the community standards. And if they would find the work taken as a whole to serve the prurient interests, fancy word, work depicts or describes patently offensive way sexual conduct specifically defined by state law, whether the work taken as a whole lacks serious literacy, artistic value, political value, or scientific value. So it looks like an objective, reasonable, prudent person test, applying those community standards if they serve the prurient interests in a patently offensive way. The Miller test to obscenity, objective, looking to patently offensive, advancing the prurient interests. So conduct that communicates in the Spence test, There is certain conduct that can communicate and where conduct overlaps with free speech. In the Spence test, we found that the test is the intent to convey a particular message, such as maybe a vow of silence and gathering, or maybe perhaps laying on the ground and having signs that signify, for example, in the AIDS crisis, where folks did die-ins, where they pretended they were dead in order for government actors to act and invest money in HIV/AIDS research. That was one example of that intent to convey a particular message through conduct. Looking to the surrounding circumstances, and a substantial likelihood is that a great message would be understood by those who view it through a reasonable audience. So we look to the intent to convey a particular message, and we look to surrounding circumstances and the likelihood if that message would be understood by those who view it. We get the O'Brien test, where the government may regulate conduct when it is not unconstitutional. It furthers an important or substantial government interest, unrelated to suppressing free expression, and incidental restrictions on free speech no greater than essential in furthering the interest. And remember, no pure speech or unconstitutional. Time, place, and manner restrictions get intermediate scrutiny. We look to the Stewart case we talked about, where heavy presumption of invalidity, where there is an extent public prejudicial nature of pretrial publicity. Order would mitigate publicity's effects. How effective such an order would be in order's precise terms. We talked about various facial invalidity for the collateral bar rule, on whether you need to actually follow that restriction. Make sure that you remember that if it is facially invalid because it regulates, it has a content-based restriction, you don't have to follow it. But if the facts are absent of that, then you do have to follow it, and then follow the legal mechanisms to challenge it. Now, in Barnett, remember that government cannot compel or silence speech, verbal and symbolic, unless there's that clear and present danger in that clear and present danger test. And as part of that incitement of legal activity, remember the old area of law, which was the risk formula approach, where the potential harm discounted and probable justifications to the restriction. Remember hostile audience, when a public speaker incites audience to imminent riot, the police may stop her speech, but when police can handle the crowd without suppressing speech, suppression violates the First Amendment. So we look to public safety as a public interest here. So if the police can actually handle the crowd without suppressing speech, then the suppression actually violates the First Amendment. And that is the first part on speech. Remember, just generally here, that to be constitutional, content-based speech restrictions must be low value, such as fighting words, obscenity, libel, etc., or be narrowly tailored to further compelling government interests to get that strict scrutiny. Remember, avoid for vagueness. If a reasonable person can't tell what is permitted, then it's unconstitutional. Overbreadth, if it's overly broad, then it's void or unconstitutional. If it substantially regulates more than the Constitution allows, and a person that the law, of which the law applies, is unconstitutional to others, if it creates that disparity. There was the listener versus reasonable speakers. A true threat is usually unprotected. Unprotected means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular group or individual, or group of individuals. So related to free speech, we have this issue of freedom of association. The Germain analysis provides that government and employees' dues can be required of members to support activities germane to union or state bar functions, but non-members must be able to opt out. But an opt-out was not sufficient. It has to actually be an opt-in, so you have to actually voluntarily opt in if it's not related to the state functions. So that germane analysis. So that might be outside the scope of one's job duties, for example. Government may only prohibit membership if proof that one person actively affiliated with knowledge of a legal and specific intent to further an objective. So if a person actively affiliates with, like, let's say, an illegal group, with knowledge that it is illegal, with a specific intent to further that objection, then the government may actually prohibit that membership. Freedom of association, remember, is inseparable as an aspect of liberty assured by the Due Process Clause. It's integral to speech and assembly protected by First Amendment. Effective advocacy is enhanced by a group association. And so that's part of the freedom of association, where government can actually restrict membership in an illegal group as if that person understands that it's illegal and joins that group to advance some sort of objective that may also be illegal. So now we'll talk about forums, places available for free speech. We'll first discuss the issue of traditional public forums. Now, the general rule here is that the government must allow public spaces for speech and can only regulate to ensure order or some sort of convenience. And so remember that in that traditional public forum, you have time, place, manner restrictions. Restrictions must be narrowly tailored and must serve as significant government interests or important, and leave open, ample alternative communications. You can't fully close the ability to actually have that speech. This would include public parks, door-to-door advocacy, sidewalks. Once the forum is opened up for assembly or expression for some groups, government may not prohibit other groups access. So if it's open for specific groups, they can't discriminate based on other groups, unless there's that issue with membership of an illegal group, where the person joins with the knowledge that they're trying to advance some sort of specific objective that falls in line with illegality. And if it's content-based, if there's a content-based restriction, remember strict scrutiny applies. If it's content neutral, look to the manner of the time, place, manner restrictions, and if they're narrowly tailored, they must serve significant government interests. But cannot fully close. It has to leave open alternative communications. It can't fully close that speech. Otherwise, it would be unconstitutional. The second forum, designated public forums. Government property is not traditionally a public forum, for example. Designated public forum might be the same analysis as to the traditional public forum, such as maybe universities that open to student groups, that open property to certain groups to use student buildings and cannot exclude other student groups. However, they're not really open to the public, they're open to students, for example. So public colleges, University of Hawaii, University of California, Berkeley, these colleges can actually decide whether or not to open buildings only to students. Those are designated public forums. Kind of the same analysis as the traditional public forum, where content-based restrictions will get strict scrutiny. Content neutral, look to time, place, manner restrictions if they serve a significant government interest and they meet narrow tailoring. Third on our list here, we have limited public forums. This might be like a post office, I think. So look at this as a school uses facility for Bible study after hours, or maybe perhaps it depends on the time, place, manner restrictions there. Subject matter restrictions and specific ideas, okay. The restriction must be reasonable and not discriminatory based on viewpoint. There is a UC Hastings case, public university policy requiring registered student orgs to accept all comers in constitutionally reasonable and viewpoint neutral. And we also have our last forum, which is which are non-public forums, where the government can close to all speech in government properties, non-public. This might be like a government office that's not open to the public. Maybe it could be like the Department of Education. Time, place, manner, regulations, restrictions are valid. Remember our rule. They have to be content neutral. They have to leave AACC, ample alternative channels of communication. They have to serve a government interest. That has to be a substantial, or you can say important government interest, and they have to be narrowly tailored. So remember, we don't allow content-based restrictions. We can't fully close the channel of communication. We have to provide ample alternative channels of communication. We have to serve some sort of government interest that is important or substantial, and we've got to have narrow tailoring. These time, place, manner restrictions are deemed sufficiently narrowly tailored as long as they are more effective than no regulation at all, even if they are not the least restrictive or intrusive method. So again, time, place, manner restrictions are deemed sufficiently narrowly tailored as long as they are more effective than no regulation at all, even if they are not the least restrictive, intrusive method. We don't need necessarily the least restrictive or the least intrusive method. We just want more effective than no regulation at all. So that is part of the narrow tailoring. It doesn't have to be, it's distinguished versus necessary. That's why the courts have used the words narrow tailoring as opposed to necessary. So remember, more effective than no regulation at all doesn't necessarily have to be the only method. It just has to be the least restrictive method. So in a licensing system, remember that licensing systems must serve an important government interest and leave almost no discrimination and provide procedural safeguards, another key word. And regulation must be narrowly tailored. So procedural safeguards such as some sort of permitting process and clear criteria if there is a permitting process. So lastly, we'll talk in this video, I think we'll have a separate video for the religious clauses. That should be pretty quick, but for this video, lastly, we'll talk about certain other types of speech. Commercial speech. The general rule for commercial speech is that non-deceptive, non-illegal advertising may be regulated if the restriction is justified by a substantial government interest, the restriction directly advances their interest, and the regulation is the least, not more extensive than necessary, needed to achieve that interest as part of narrow tailoring. So not more extensive than necessary is another way to remember narrow tailoring. And commercial speech does no more than propose a communication transaction, references specific products, and has economic motivations. So that's commercial speech. We look to some sort of commercial transaction, referencing specific products and economic motivations. And we can regulate deceptive advertisements. We can say that they that such regulations directly advance the important or substantial government interests, and it is narrowly tailored by regulating such that it's not more extensive than necessary to achieve that interest as part of narrow tailoring, but it doesn't necessarily have to be the least restrictive intrusive method. It just has to be more effective than no regulation at all. So does a speech advertise illegal acts or deception, or is it unprotected in the Central Hudson test? Does it advertise illegal acts? Such as that example of false advertisements? Is a government restriction justified by substantial interests? And is the law directly advancing the government's interests? And is a regulation no more extensive than necessary to achieve government interests? If those pass, then the government may actually regulate the commercial speech, even if it only relates to a commercial transaction. Related to what we just talked about before in that other chart, here profanity and indecent speech. Remember, it's not obscene since not significantly erotic. If that's part of our case, fighting words are directed at the hearer usually. In Cohen, the case general rule, state cannot punish public displays of expletives. And pure speech, if you have a pure speech issue, then no O'Brien analysis is needed and no Spence within pure speech. But then we can look to our analysis on obscenity, where we apply that reasonable person in the applying community standards under the Miller test, and whether or not that the work describes a patently offensive way, some sort of sexual conduct defined by state law. And we look to fighting words, whether or not there's an incitement of imminent harm or objectively likely to produce legal action, or the speaker wants to cause, has the intent to cause imminent harm. Incitement to violence, we look to our tests there, where the old law was clear and present danger tests. But now we can just apply the reasonableness approach, where state laws are of unlawful overthrow government are valid exercise of police power under that reasonability test. Old law was the risk formula approach. Now government cannot, we can still talk about the clear and present danger approach, but I think it's better just to look at the Brandenburg tests when it comes to incitement of illegal activity. Just thinking about the Brandenburg test for any sort of imminent harm in the context of incitement to violence, if the speaker wants to create that imminent harm, and if it's in an objective reasonability test. Fighting words, the Chaplinsky test for fighting words, it's a reasonable person test. Words, if whether or not those constitute fighting words, we look to the words directed to the hearer, and that hearer we look to which by the very utterance, if they tend to inflict some sort of injustice or incitement or immediate breach of the peace, then it's a violent reaction. Under the Chaplinsky test, we look to the words directed to the hearer, and it's a reasonable person test, similar to our Miller test on obscenity. So a lot of these are related to the reasonable person test. Remember, under sexually explicit speech, we look to time, place, manner restrictions regulating secondary effects. Are they content neutral? Are they narrowly tailored? Advancing some sort of substantial interests? Are they not overbroad? Are they not vague? Do they leave open alternative ample channels of communication? We talked about that, advancing the substantial interest. And is it more effective than no regulation at all, but not necessarily the least restrictive? If that is so, then here we can apply the lower standard. Rational basis review is a way to think about it. Under the O'Brien test, we ask if the government action is unrelated to suppressing or targeting expression to further an important government interest, or if there's some sort of incidental restriction on free speech no greater than essential necessary in furthering the interest. Also relates to what we talked about in narrow tailoring. If that suppresses the conduct, then that communicates there's more demanding scrutiny, kind of like intermediate scrutiny. If there are no secondary effects unrelated to content-based restrictions or regulations of conduct, that communicates, and that's intermediate scrutiny. And the regulation furthers some substantial or important government interest and relates only to secondary effects and not suppression of free speech. Then we'll look to the legislative history to combat secondary effects. We'll look for de minimis effect. Dancers can still wear other garments, even if they're not fully nude, and private possession of obscene materials cannot be punished. But however, that's distinguished between forms of materials which endanger children, as we have written there, because protecting children is an important interest. It disincentivizes that creation of that material. So remember, looking for the secondary effects. Yes, so looking to secondary effects only, unrelated to content-based regulation of conduct that communicates, versus secondary effects and not suppression of free speech, such as protecting children as a secondary effect, or other examples that we could possibly think of. In our next video, we will conclude with the First Amendment religious clause discussion.